if you go to the Zoom window where you see the video going and hover over it, there should be a button called Share in the middle of the screen when it pops up.
Let's see here. I don't see that actually. Just over the, let's see here.
So if you are you in full screen mode right now?
Yes.
Okay, exit full screen.
Okay. All right.
Take your cursor off of the Zoom window.
Yep.
And then if you roll it back over, you'll see a pop-up at the bottom bar of that window to share your screen.
Huh. Let me try this. Okay, are you seeing that?
Got it, Peter.
Fantastic, fantastic. All right. So, okay, here we go. All right. Now that I've gone over the technological challenges, so today we are going to be talking about alternate sources of capital for funding your syndications and real estate deals, mainly focusing on, as you see here, syndications and joint ventures. We will talk about plenty of stuff in between, and everyone should feel free to ask any questions you want. Here is a little bit about me, and my thunder was stolen a little bit. I do have that disclaimer on the bottom. This is for educational purposes. I am a lawyer, but not your lawyer, as has been said. So I'm a partner in both the real estate and corporate groups at Sklar Kirsch. We're based here in LA. In sunny, usually not necessarily today, but we're in California. Lots of experience on the commercial real estate side, representing, as was previously said, developers, operators, syndicators, as well as equity providers, investors, and lenders. I also have lots of experience on the corporate and security side, which is important for syndications as well. We'll talk about that a bit. I know there's another presentation, I think, from Jillian Sidoti, who's fantastic, specifically focused on securities. So we will touch on that. It's important for this seminar as well, and happy to answer questions, but definitely attend that session later today, I believe it is. I'm also an active real estate investor myself. I've invested in several syndications, lots of multifamily, self-storage, a number of other things. Some clients have convinced me to invest as well. So, all right. So let's talk about a little bit of vocabulary quickly. So what is a syndication? You hear about that term a lot. Basically, it's simply the pooling of funds from numerous investors, 5, 10, more, and channeling those funds into a common enterprise. So if you're a real estate sponsor, you have a multifamily project, as is apropos for this conference, and you need equity for that project, you're going to go out, maybe first to friends and family. Maybe you've built an investor database, but you're going to wind up with 20, 30, however many investors all investing in your project. These investors are going to write, I have here smaller checks. Now those checks could be, 50,000, 100,000, what have you, and they're not small, but the point here is they are not writing, one check from one or two people for the entire amount of your equity. It's a number of checks from, people, each of whom are investing a smaller amount proportionally. All these investors are totally passive. They're LP or limited partner type investors. They don't have any say, any control over your project, as we'll see later. And they're typically not professional real estate investors. Now, this is not always true. I think, again, on this couple of the panels in this conference. There's folks like Jeremy Roll, who's a client of mine who is a full-time passive investor. But for the most part, there's doctors, lawyers, there's lots of people who have, quote unquote day jobs who are going to be investing in these syndications. And as opposed to, we'll get into in a minute, joint venture investors who are, professional. They often have a lot more folks on staff. They're sort of full time in the real estate business. And again, the sponsor in a syndication, the sponsor is the developer, the person who is putting the project together, typically has total control over the project, all decision making, when to sell, what loan to get, etc. Now, syndications can be single asset syndications, meaning there's one project that you're raising money for, or you can raise money for a fund, which means that you raise money once, you raise a pile of money, a lot of money, and then you as the sponsor use that money and deploy it over, maybe 3, 4 or more properties. All right, so let's talk about joint ventures. The first question is, what is a joint venture? There's a lot of misperception about this. Is it an LLC? Is it an LP? And really, it could be either of those things or more. And the JV structure really is simply, one, maybe two people coming with the money, and then there is, one person, you, the sponsor. Right, so it's a joint venture could be an LLC, it could be an LP, or it could be a corporation, although frankly those are not used very much. It could even be a contractual joint venture, which is simply a piece of paper between two entities where you set forth the terms of your working together. Although again, in my world, typically the two parties do form a new entity, that being an LLC, usually sometimes an LP. Again, the JV partners typically, whether they're family offices, private equity companies, that's typically their job. They typically have a full staff. Maybe they've got family funds, or maybe they've got, they've raised funds of their own. But they are a lot more learned. They're going to be a lot more involved in your deal. And as we'll see later, they will have what's called major decision rights in each of these joint ventures that you would tend to do, as opposed to the syndication investors who would be totally passive. All right. So here are a couple additional types of arrangements or types of capital sort of beyond joint ventures and syndications. We work a lot with TIC structures or tenancy in common structures, which can be useful when an investor has money from a 1031 property. They've sold a prior property. They have gains from that property that they don't want to pay taxes on. Again, no doubt there is a more in-depth panel on 1031 exchanges, but suffice it to say that the person doing the 1031 exchange can't take that money and simply buy an interest directly in a syndication LLC, or they would have to pay tax on that money. So this certainly can complicate a deal structure. Have to be acceptable and familiar with the particular lender that you're using. But it is certainly, a viable source or another alternate source of capital. Again, another source is preferred equity. This can be used as we'll see later. The other structures that we're talking about can be used in connection with a syndication or joint venture. And preferred equity is exactly what it sounds like, right? It's a equity slug, a class of equity that is preferred in that it is going to get paid first above your sort of more common syndication equity. And it is normally structured as a coupon or a bond. It's similar basically to a loan in that, it may say, the preferred equity folks get a 12% return annually, and they will, get that similar to interest on a loan. although this is equity. And preferred equity, can come in at the beginning of a deal, at the same time as the other equity investors. I'm working on a transaction right now, which is an assisted living deal where the client did a raise regular syndication. They were able to acquire a property next door and expand their project, and they are now layering in a layer of preferred equity on top of that, and getting their existing investors' consent, but it's coming in later in lieu of them getting just a loan, because they're going to go out and get a construction loan, and they don't want a situation where that construction lender is worried about a second lien on that project. So that's another type that can come in. And of course, when we're talking about capital structures for something like a multifamily project, of course we have to talk about whether you're doing a syndication, a joint venture, or another structure or combination. You're most likely in all cases going to have a bank loan or a private money loan in conjunction with the acquisition or the construction of that project. All right, so now that we've sort of laid the groundwork for joint ventures and syndications, let's talk about some of the advantages and disadvantages of each. And starting with syndications, when you're putting together a project, one of the advantages that we've already talked about is that your syndication investors are passive. They don't vote. They're not going to make decisions. They're not going to be able to tell you typically when to sell, what loan to get, who to use as property manager. You're going to have a lot more freedom if you're doing a syndication. Now, obviously, all of this is dependent on how the documents are drafted. And sometimes in our syndications for specific clients, syndicators will put in anticipated holding periods, or even occasionally that investors had a right to get out if a deal wasn't sold by a certain time. But typically you as those of you who are sponsors and syndicators, you want to be able to have full control. Maybe tell your investors that your business plan is, we're going to hold this property for approximately 3 to 5 years, but if we get into year 5 and the market takes a dive, we don't want to be forced to sell at the wrong time, or if we get an offer, earlier and it is a 25% IRR, then you want to be able to do that too. So you want to have control. A potential advantage could also be that these investors are less sophisticated, and this is not to say, not to slight anyone. It's not to say that there aren't sophisticated passive syndication investors. There certainly are, but they tend to be, as a group, less sophisticated, as we talked about before, and they're not doing real estate as their profession and digging as deep into these projects. They're going to be somewhat less sophisticated typically than your joint venture folks are going to be. We also talked about the flexibility to do a deal-by-deal syndication or raise a fund, which is, again, easier and I think more prevalent when you're doing a syndication. And in that sense also provides you that flexibility. You can generally dictate the structure and terms to your syndication investors, especially in the market today. It's as everybody knows, been very hot. There's a lot of money. There's a lot of syndicators and sponsors coming in, and certainly, at least in my view, we're nearing the peak, I think, or getting overheated generally in the multifamily market. But the point here is you are going to put your deal together, tell your investors, here's the deal. We'll talk a bit more about this later, but it's a 70-30 split. There's an 8% preferred return, and you're going to put the documents with that structure in front of them and tell them what it is, rather than negotiate it along the way and have them come back and say, well, no, I'd really like to do a 12% preferred return. Another advantage is typically that for when you're starting out as a syndicator, it's going to be easier for you to raise a syndication than go to a family office or private equity firm and most likely convince them to do a joint venture for one of your beginning deals. You may start with a syndication of friends and family. um, you may broaden out from there. Friends of friends, maybe parents or other relatives have their friends who might want to invest in you. And also when you're going to do a syndication like that, and especially starting out, the people that you're raising money from, if you don't have several deals, the experience under your belt, they may just want to invest in you because of you. They may know you, from a prior life. You're a successful attorney like me. We have a lot of former attorneys as clients, brokers, even people outside the real estate industry who have been successful in other realms, and then they go into real estate and they have at least initially 5, 6, 7 folks who they can team up with. And in that sense, it's it's easier in a way to put that deal together. Now, on the disadvantage side, there is, as we alluded to earlier, in a syndication, there's more paperwork, and it may be more expensive to put that deal together. We'll see a little bit more later as far as the structure goes, but you're typically going to have an operating agreement. You're going to have your securities disclosures. It can be more expensive to come to somebody like me, and put those deals together. We'll talk a little bit more again about that in a moment. So here, as we said, a syndication is not only a real estate transaction, but it is in fact a securities transaction. And in a securities transaction, you're taking your investors' money from a pool of people who are going to be passive in a common enterprise, and they are relying on you. They're relying on the sponsor and the sponsor's efforts solely. They're not involved, and your skills and your experience. So that quintessentially is, in a sort of simplistic view, that is what a security is. You are taking people's money. You're basically doing all the work. They are totally passive, and you're going to need to prepare a private placement. You're going to need to prepare the operating agreement, subscription agreement, and all of the paperwork. Can be costly. Another disadvantage, we put on the advantage side, that investors are less sophisticated, and that can be an advantage. It can also be a disadvantage. Sometimes less sophisticated investors are going to ask you a lot of money, a lot of questions. They're not going to understand the structure. You're going to take a lot more time potentially to explain it to them. So it could also be a disadvantage. Now, it could also be, going along with that, it could be more work to raise money in a syndication rather than a joint venture, because if you think about it, in a joint venture, you have 1 or maybe 2 people who are going to write you a check for all of your money. And once you have those people in your world and have them interested, that's a lot easier, right, than going out to 10, 20 people, explaining. Maybe you have to travel. In any event, you're going to be doing phone calls. You're going to be tracking down, 10 subscription agreements, 20 subscription agreements. That's a lot of work, and you're going to be doing all of that while you are, trying to put your acquisition and your real estate transaction together. So that can be, in fact, more work potentially to raise money on that side. Although, as we discussed, when you're starting out, it's probably a better way to go. kind of in line with what we were talking about above, smaller, less sophisticated, or investors who are writing smaller checks. Sometimes those are or can be the investors who cause the most issues, need the most hand-holding. If you have somebody who is writing a $25,000 check and it is, the money that their family has to invest, or even if it's not, if they're writing smaller checks, they may, for some reason, they may be the ones, and often are, who ask the most questions. And, if your K1 is late or something happens, or even if it doesn't, a lot of times in my experience, we've had clients who those are the folks who seem to take the most time and require the most hand-holding. And again, it is possible because of those reasons. It may be harder money to access. Again, it's more work. You may have to travel. You have to build that investor database, and there's just simply more work to do. There's more people and more paperwork to track down. Okay, so on the flip side of that, let's talk about joint ventures and some of the advantages and disadvantages there. Again, there's probably less paperwork than, you are not typically doing a securities transaction on the joint venture side. Your JV partner is going to be active here, so they're not solely relying on you. These are tend to be more sophisticated folks who are doing this, as their job. They're going to be more involved. We'll see, later that they again have major decision rights. So typically here, you don't have the PPM. You're not going to have a subscription agreement. You're just going to have a simple joint venture agreement, or LLC or LP agreement. Another advantage could be that these investors are more sophisticated. They understand complex deal structures. They're going to be able to work with you in structuring the document, putting in deal terms that may not be typical in a syndication. So that actually could work to your advantage. Again, there's the flip side of going out to 10, 20 people. It's less work to raise the money, after you've gotten a few of these people in your database or a few JV deals under your belt, and you can just pick up the phone, and again, talk to one person or two groups, and those people potentially could write the whole equity check for that transaction. They may be more experienced, and again, this is their world, right? So unlike your syndication investors who typically are just going to write you a check and maybe that's it, maybe invest in a future deal, lots of times, if you pick the right joint venture partner, they can make other introductions, brokers, other equity partners. They're going to know certain lenders. They may have lenders who are preferred, who have worked with that equity group before. So in a lot of ways, once you can get to the family offices and private equity folks, that's going to open up and make it a lot easier to start really building, on those relationships. Obviously, they can, write, as we talked about, they can write larger checks. They can move very quickly. Usually, again, they're family offices with their own money. Or they have a fund themselves, and there's one or two decision makers, and these transactions, if you have the right relationships, can move very quickly and get funded very quickly. Okay, so one of the, and probably the major disadvantage in a joint venture as opposed to a syndication, is that the JV partner gets major decision rights, and sometimes more. So we'll talk a little bit about that more when we sort of see some of the provisions and get into the structure a bit more. But to suffice it to say that these are not going to be passive investors. They are not going to let you sell whenever you want. They may, have veto rights over the lender, over property managers, what have you. So it's a very different world when you are on the joint venture side. As we talked about, it's harder money to access at the beginning, and going to be more work because you can't simply pick up the phone, and call a family office or call a joint venture partner if they don't have any reference as to who you are. They haven't been referred to you. You don't have the experience. It can be challenging to build those relationships, and it takes a while. It takes a long time to build relationships with private equity folks and family offices, and going to conferences, and maybe being involved as a partner with another operator who's on a deal that they are on. But in that sense, it can be more work, at least at the outset, to raise money from them. Typically, you are doing, individual deals with joint ventures. It's less prevalent to have a fund structure with these joint venture equity partners. There are programmatic joint ventures. We're doing some, but typically the joint venture partners are, and again, especially at the beginning, they're going to fund one deal, see how that goes, and then they're going to work with you on another deal. So it's less prevalent to have a fund structure on the joint venture side. And again, as we discussed sort of briefly above, the terms are typically going to be worse. And by worse, I mean, you are not going to be dictating to your investors what they will get and deciding yourself what the terms are. And the equity partners are going to be more demanding. There are going to be maybe more hurdles, more steps in the waterfall for you to get your promote or carried interest, to get to the point where you as the sponsor can really start to make money. And in addition to that, they are going to be more, they're going to scrutinize what you are getting paid as far as fees, acquisition fees, disposition fees, maybe asset management fees. And they are going to analyze those individually in a lot more detail typically than on the syndication side. And one other thing we'll talk about a lot more later is, as opposed to on the syndication side, where if the venture needs more money, oftentimes you will just do a capital call and maybe your investors can participate in that or they won't. There's no penalty, no mandatory capital calls, and maybe they'll just experience dilution. On the joint venture side, there's going to be a budget, there's going to be a development plan, and if you go over and the venture needs more money, an unforeseen thing happens, the roof caves in, there's more work to be done on the value add than you thought. Oftentimes, you as the sponsor, even though the joint venture partner is going to be putting in 90, 95, whatever the number is of the equity, you are going to be putting in that money potentially 100% as what's called a cost overrun, and maybe not even getting contribution credit for that. So that's also very different. Okay, so let's talk about what a sample syndication structure looks like. Here we have Sammy sponsor, and this is based on a deal I'm actually working on right now, which hopefully will be closing this week. 464 unit multifamily property in Houston, and he needs equity for that project, and he's going to go do that as a syndication. So what is that going to look like? What are the documents and what are the necessary steps for him to put that deal together? Step one, he's going to go find interested investors, and I've got step 1A here, which is structuring the deal, and sometimes these are intermixed. Sometimes the deal structure comes first. It just really depends, right, whether you have a stable of investors that you can already go to and you can just proceed to structure your deal and go out to those folks, whether you are building that stable of investors, or talking to friends and family for a first or second deal. And maybe you'll talk to them and find the investors and see what they might be expecting before you put together this summary and initial structure on your deal. So after that, you contact somebody like us, or you may do that at the structuring stage, the executive summary stage. We have, I would say, a majority of clients who put that together themselves, but frequently we're involved in helping them put together the executive summary, and it helps to get your attorney and your whole team, right? Your CPA, whoever your advisors are, it helps to get them involved right from the outset, so you're not putting something in your summary or your structure that isn't going to work when we go to do the documents, or isn't going to work, is totally off market. So then you're going to put together the legal documents, and as we said, most likely you're going to structure your syndication as an LLC, maybe an LP in certain circumstances, though the majority are LLCs. The typical structure is you'll have the sponsor, the developer, or an affiliate of that entity, which is the manager or managing member of that LLC. And again, you're going to have a class of LP limited partners who are totally passive, with no or almost no voting rights in that structure. We're talking about securities here. You're going to be typically doing a Reg D offering. And again, I'm happy to answer questions. I know there's a seminar later. I don't want to go too much into detail there, but you really do need, and I should have mentioned this when you work with counsel, if you're doing syndications, really need a lawyer or a firm who's well-versed both in real estate and in securities. You're going to have to put together a private placement or other disclosure document. You're going to have an operating agreement, as well as subscription agreements, which is what all of your investors are going to sign up, which typically includes reps and warranties, and also a questionnaire detailing whether they're accredited. And in certain circumstances, if you're doing what's called a 506C offering, you will get those folks verified as accredited. And then basically you're going to take those documents, and you are just going to present them maybe with your summary. What we do oftentimes is we attach the executive summary as an exhibit to the deal documents, and you are going to present those as a sort of take it or leave it type offering to your investors. And they're going to basically say yes or no. So there's not going to be any negotiation. Maybe one or two of them will say, hey, I found this, but if you have 10, 20 sets of documents out there, and you've got 3 or 4 investors who have already signed up, you're not going to be cutting deals, changing those documents with your other investors, unless you're doing what's called a side letter agreement with one or others of them, which we'll talk a little bit about more later. But you're not going to be changing your private placement, your operating agreement or your subscription agreement once you have them out and people are signing up. And then again, while you're doing that, you're putting your real estate deal together, right? So you're picking the lender, you're signing up the property manager, and all of these things in a syndication, again, you're doing on your own. None of your syndication investors typically are saying, oh, you can't use that property manager, or you can't use that lender. Those are all things that are going to be up to you guys. Those of you who are sponsors. Okay, so same type of deal. Now Sammy wants to do this as a joint venture. So the first thing to do here is find a suitable and interested joint venture partner, or maybe you're going to present the deal to a couple of them. Step 1A again here is structuring and putting together the summary or term sheet. But here you're going to do this as a negotiation with the joint venture partner. They are going to prepare the deal with you. It's not going to be a take it or leave it. And Oftentimes, the counsel for the joint venture partner may be presenting you with a structure or taking a first shot at that term sheet. And again, when you bring us or your lawyers in, you are not just going to be preparing your documents in a silo. You're going to be presenting a draft of the joint venture agreement to your joint venture partner, or frequently that joint venture partner's lawyers are going to say, we, especially, if it's a newer relationship, look, we have, our form joint venture agreement that we need to use, and we're going to be presenting it to you, and then you would, work with us or your lawyers to get comments, pair that back. That agreement is most likely going to be very pro equity, very pro on the equity side and not pro sponsor. Again, here, most likely structured, you're going to structure a new LLC. These are often, and we always recommend Delaware LLCs or LPs. There's not going to be a private placement. You're not going to present them with a disclosure, a subscription package. And if you do, at best, they're going to say, yeah, these are not really the correct documents. We'll get you something, or they're going to say thanks but no thanks, because it's not appropriate in a joint venture deal to have a PPM put together and presented to the joint venture partner. Again, this is going to be potentially presented by their lawyers. It's going to be a full, several rounds of negotiation back and forth between the sponsor and the joint venture partner, as well as their lawyers and other advisors. And in this structure, typically the sponsor is also the manager or the managing member or the operating member, but the equity partner has these so-called major decision rights. It can also be that, frankly, the equity partner says, nope, you can be the day-to-day operator, but we are going to be the manager of the entity of the LLC, and sort of have the overarching ability to tell you what to do on a daily basis, pick and choose everything from the lender to the property manager, and be the, file the taxes for the entity, even though you as the sponsor are doing all the work. So step 3, you'll see here, as opposed to the syndication, is a joint review and negotiation of loan documents. You're going to get loan documents, and the equity counsel is going to want to look at those and make comments. Excuse me. They may actually want to take the lead in negotiating those loan documents. They may demand, or want to look at title and survey. And in fact, they may say, depending on who the equity partner is, they may say, we want our lawyers to do all of that. And then you, the sponsor, you're just the operator, but we're going to negotiate all of that. So it really runs the gamut, but suffice it to say that it will be a lot more decision-making and a lot more control on the part of the equity side, rather than just you, the sponsor, doing it on your own. So I think we covered these already. The equity counsel is going to be either running the show or simply just a lot more involved on all of these decisions. Just a brief review here. There's TIC structures as another source of capital, preferred equity, which we talked about. Every deal has bank financing. And all of these, again, can be used either in tandem with a syndication or joint venture, or on their own. There are tax credits that certain deals can get if they're in historical realms. Opportunity zones, one of the hottest topics now. We're doing 4 or 5 of them at the moment. That's a certain type of structure, which again can be combined with a syndication or a joint venture. And then sweat equity, right? For all of those of you who are sponsors, you're putting the deal together, you're underwriting, doing the acquisitions and the legwork, and that is, certainly part of how you get paid and part of the capital structure, and always needs to be taken into account with all of these other types of capital in the structure. All right, so I'm going to take a quick moment here to try to answer some questions. I know there's a window which I am trying to locate here to see how to get to any questions that anybody may have. Let's see. I don't know, Danny, do you know how I would do that or how I see that box? Let's see here. Q&A, I think. Okay. So what I'm looking at, it doesn't look like there are any questions. I think I'm looking at the right thing here in the Q&A box. Not a one, huh? You all understand all about joint ventures and syndications. All right. So let me close out of this here. Okay. So if there are no questions, we will move ahead here. Whoops, that's moving backwards. Okay, so let's talk about some typical documents and sample provisions in these two structures. We already sort of touched on this. Why is my slideshow? Okay, let's get back to the slideshow. Okay. Typical documents and sample provisions. We already talked about this a bit, but how do these play out in practice? So the syndication documents generally, we talked about there are three main documents, the LLC agreement or the LP agreement, sometimes simply called an operating agreement. This is the document where all of the distribution waterfall, the governing laws for the members and the manager are all going to be set forth in the LLC agreement or the LP agreement. Next is the subscription agreement. And again, these three documents are necessary, the subscription and the disclosure document, the PPM, because what you're doing in a syndication is you are selling securities, right? You're doing a real estate transaction, but you are basically getting your subscribers, your members, to sell equity. They're buying equity, they're buying units of membership interest in your LLC. So that subscription agreement is where your investors, tell you how much they're investing. They make representations that they're accredited, that they're not buying with an interest to resell. Those kinds of things. And there may be some reps and warranties from the company as well with respect to the amount of the offering, the term of the offering, when it lasts until, things of that nature. And then you have, the sort of most important document in a securities offering, the private placement memorandum or the disclosure document, which basically says, here's the structure of the deal. It describes the background of the business team typically. It will describe how the sponsor, the developer, gets paid. And then it will have what is called risk factors, which is perhaps the most important section, where you're telling your investors, here are all of the risks that any investor would consider material when making a decision to enter into this transaction. So, the property, the multifamily property we're buying is built on a former gas station. It's possible there could be environmental issues. It's in a zone, a region where there's lots of hurricanes. And then more general things like, there's no guarantee of this return. This is a newly formed entity. Pages and pages of all of the things that are risks, that could cause your investors not to get the returns that you're projecting, and everything that they could possibly need to know as to why there is there are potential risks, and they may not get the returns that you're telling them that they should. So that's what goes in the disclosure document. And again, think of it as a really large insurance policy. It's going to protect you as the sponsor to have put down everything that could possibly go wrong, or that may be material to these folks. All right. Another facet of these deals is that they will actually require you to do securities filings. Again, we're talking about Reg D, Section 506B or C offerings typically. And those require you to actually file both on the federal level and with the state regulators. You're going to file a Form D on the federal level. And then you're going to file what's called blue sky filings with respect to each individual state where you have investors. And you can do state-specific offerings, and there are variations on that, but I'm not going to go again too far into that, as I know there's other folks talking more in depth about securities issues and syndications. We talked a little bit before that you might have a side letter in these deals. And if you do, by the way, if you do have side letters and you're going to use those, you need to disclose in your private placement memorandum or your disclosure document to all of your investors that you may have side letters, which in essence basically is a letter on the side, not in the main documents, maybe with one investor saying, look, I will share a part of my promote a part of my carried interest with you, or in some way altering the deal for that one investor who maybe has invested with you several times before. But be aware that cannot alter the arrangement. It cannot be to the detriment of the remainder of your investors. So just be cognizant of that. Okay. Again, the typical structure is that the sponsor or the manager, has the sponsor is the manager, and then you have a class of investors. You might have a Class A and a B class. Class A being your investors, Class B being the sponsor and its affiliates getting the promote, and the Class A, your investors would be totally passive, have no voting rights, as opposed to the Class B, which is the sponsor, would have extensive voting rights, and again be able to make all the decisions. So that's generally what the syndication documents look like. And one more thing here, if you set your deal up with the manager, with the sponsor as the manager, and your investors are passive, and you simply call it a joint venture. You tell your investors in your documents, you just have an operating agreement, and you say, this is the joint venture agreement. It doesn't matter, right? It doesn't matter what you call it. If what you're doing is actually this structure, you are selling securities, you are doing a syndication, and you need to follow, you need to follow all these steps. Okay, so let's talk about on the joint venture side, what these documents are going to look like and what this structure is going to look like. Again, a joint venture is not a particular entity. Typically, we do form LLCs or LPs, but that just means sort of the coming together in a business relationship of, in this case, a multifamily operator or developer and a sponsor. So it's potentially going to be, it could be a corporation or just a contractual, documented joint venture. Although in this world, again, we don't typically see those. There's one main document, no subscription agreement. There's no private placement. Again, your joint venture or potential joint venture partners are going to look at you strangely if you present them with a private placement. And there's no requirement typically for securities filings in a joint venture arrangement, right? Because your partner, your equity partner is going to be involved, and even if they're not the manager, they are going to have major decision rights. They're going to be involved. They're not going to be solely relying on that phrase, the sole efforts of the promoter, the sponsor, to run this deal. Again, also there are typically no securities filings, as we said. And there's not going to be a side letter. There's not going to be, a side deal, right? Because there's one joint venture partner, maybe two affiliated entities, but you're not going to have another investor who's going to get a better deal, certainly, than your main, your joint venture partner is going to. And again, the typical structure here is that the sponsor may be the managing member. But oftentimes, as I said, the equity partner is going to say, nope, we are going to be the manager of the entity itself, and you are just going to have the title as the operating member, basically, and we're allowing you to run the day-to-day. But we have all the rights, and we can remove you, in a number of different ways. One thing I didn't actually touch on is that you can have removal provisions in a syndication. Typically, when we're drafting, we are drafting, not always, but often we're drafting from the sponsor point of view. So we'll have removal provisions, but solely for cause, and a very narrow, limited definition of cause. Whereas on the joint venture side, you are going to be maybe removed for cause, which is a definition that can often take up a page, and often sometimes for performance. So the equity partner, again, is going to have a lot more to say about you as the sponsor running the show, and what you can do and what you can't do. All right, so here are a couple of actual provisions that I've pulled from specific documents, and I'm not going to read them all, but you can see this is a section on management, a sample provision from a document that I'm working on right now, and it basically says, except for those provisions, this is a Delaware entity, except for those provisions, that are mandated by Delaware law. And one of the reasons that we like to pick Delaware law for our sponsors is there are much less things in Delaware, that are mandated for members to vote on, and there are also much less fiduciary obligations that are mandated by Delaware law. So you can reduce or almost eliminate them. Just one reason that we like Delaware entities. Another one, for example, is that lenders, especially when you are dealing with agencies, Fannie and Freddie, they will expect and look for Delaware entities. But so here, except for those provisions which are required under Delaware law, basically you, the members, have no voting rights, and the manager can make any and all decisions, which goes along with what we've been talking about, right? The manager is going to make all the decisions. The sponsor is going to enter into any contracts it wants, choose which bank to go to, sell the property when it wants, incur what loans it wants, do the leasing in any way that it wants to, all of those kinds of things. Excuse me. So contrast that. This is quite a bit of information. Hopefully you can see it. But contrast that with what we've been talking about on the joint venture side. which is, this provision here, right? It's basically saying the members, meaning, your equity partner designates you, the developer, as the operating member, and except with respect to the major decisions, which again is going to be a long list of things. The company can do the developer can do the day-to-day stuff, but it's the wording here, right, is very different than what you'd find in a syndication document. It says the management of the company shall be the sole obligation and responsibility of, and rest with the operating member. That doesn't sound like the syndication side, where the operating member can do whatever it wants. It's an obligation, right, and responsibility. And then you'll see in this second bullet point, the operating member has to exercise good faith and will promote and protect the best interests of the company. So this is not, hey, I'm the manager, I'm dialing back my fiduciary duties, I have free reign. This is very different. Operating member shall diligently and continuously pursue the development plan, the approved annual updates, and the operating budget. So, your equity partner is going to be holding the sponsor to, this is how you said this project was going to go. This is, what you told me the budget was going to be. I'm going to ask you every year, let's do a comparison of what you told me the budget was going to be to where we are realistically, and then you're using your reasonable professional judgment. So it's all of these things, right? This is much more onerous on the sponsor than on the syndication side. So here is sort of the lead-in on the joint venture side. The corollary to that is, these are the major decision rights. And again, I'm not going to read the whole thing, but anything from executing finance documents, borrowing money, approving leasing, and again, these are negotiated on a deal-by-deal basis with your equity partner. But it's going to be a long list of things that you as the sponsor cannot do without their approval. And then you'll see this last bullet point here, the investor override, which oftentimes says, hey, it's not only that we're going to discuss these things as major decisions, and you can't do them without the investor, the equity, saying so. But if I tell you, hey, we're going to do this thing, even though you, the manager, are the operating member, that is the decision that is going to bind the company, and you are, sort of forced to carry that out on the part of the joint venture operator. One sort of other difference, a typical waterfall in a syndication, it can be fairly straightforward. It can be you pay your investors a preferred return. Maybe it's an 8% preferred return. Then the next step, it's 70% of the cash flow to your members, 30%, the so-called carried interest or promote to the manager. That's from operations. Then, it's the same from a capital event, except that on a capital event, it goes preferred return. Then your investors get their capital back. And then it's split 70-30. And here again, the manager will make the decision, when the property is sold or when cash flow comes in from operations. The manager will, the developer will unilaterally decide what is available for distribution. How much of that cash flow that we have do I need to hold back for reserves, or do I want to hold back for reserves? And the language will often say that the manager will distribute as and when determined by the manager. Maybe it's anticipated to be quarterly, but the manager, the sponsor, is going to be the one making that decision. Here in a, contrast that again in a joint venture document, where again, sometimes you have separate cash flow from operations waterfall, and sometimes you have and capital event waterfalls, and sometimes you just have one. Frequently, and then it goes 100% to the members, which may include the developer to the extent they've put money in. But often, the equity can say, nope, we get our money back, even the preferred return we get first. But step two, to return capital. And again, if you as the developer have put in more money for a cost overrun, you're not going to get extra credit oftentimes for that at this level, even though you by virtue of doing that, you have put in more than your initial contribution. And then you'll see that here there are different hurdles and different steps. So maybe you get a small piece of your promote or carried interest until, or actually in this example, you get nothing. It just goes evenly until an 8% IRR. Then at a 12% IRR, you get part of your promote at a 20%. And then only thereafter would you get the full 30% of your carried interest. There are going to be more complications and more steps such as this to go up to that level where you're going to get your full carried interest. We already talked about, I think, the additional contributions. This is what it looks like in a syndication. It's at the manager's discretion if you want to raise additional capital. Maybe you're required to go out to your initial members, maybe not, but they're not going to get penalized for putting more money in. But again, it's totally up to you as the manager. And talked about cost overruns, but here's what it looks like in practice. There's a budget, you've gone over it. If the joint venture needs money for any reason, right, other than something that is not the operator's fault, there's a war, there's a hurricane, so-called force majeure, but almost anything else. We're negotiating one right now where even an increase in the price of materials or labor, the equity partner said, nope, you've got to, when you're doing your budget, you should be able to project those things. You should be able to account for those things. And again, what is a force majeure? What is a developer only cost overrun? These are going to be things that are negotiated. But the equity, somebody who's writing you a 90% or 95 or 80% of the money that you need, they're going to be in a very strong position to dictate what those documents say. Other provisions that vary greatly, transfers and syndications. It's the manager who can say yes or no to any transfers, subject to maybe transfers for estate planning or things like that. In joint venture documents, there's going to be maybe no transfers, especially for the operating member, unless your equity partner says so. And it may actually say, look, the equity can transfer to whoever they want. Typically not, outside their affiliated group because you're, doing a deal with that group, but they may be able to transfer, among their funds or, to another entity that's managed by somebody who isn't the person that you initially signed up to do the deal with. Again, there's going to be in joint ventures, there's going to be budgets and development plans. You may have one which you present to your investors at the outset of a syndication, but you're not going to be typically providing them with annual updates. They're not going to have a say. You present a budget and in a joint venture situation, the equity partner can say, nope, I don't approve this. Go back to the drawing board and do it again. In syndications, you often have drag along rights or buyout rights for your investors, or drag rights if you want to sell the entity at a certain point rather than the property. Oftentimes will include rights that you can, sort of force your members to sell their equity. If somebody wants to come in and say, put your property into a portfolio and they just want to buy the entity, those things aren't going to be permitted in a joint venture. what you're going to have oftentimes is buy-sell rights where, at a certain point, maybe your equity partner can come to you and force you to sell to them or force a property sale, or either force you to sell to them or buy them out. So, they know at a certain point they can get out of that transaction. I'm trying to be a little bit cognizant of time here. Let me pause there before I show this guy, and go back up here, try to see. I'm not sure why I'm not seeing any questions. No open questions again. All right. Hopefully I'm giving you all the information either you already know, or too much to digest. Let's see here. I'm going to try to go back and share the PowerPoint. So let's do that. All right. Okay, I'm not sure why that happened. Okay. All right. Let's see. Okay. So just to show this slide real quick, this is what putting all of these things together can look like. This is basically an actual deal that we did here at the firm. It is a combination of three of the things that we've been talking about. It's a combination of a syndication. You could see, I'm not sure if you could see up here on this side, passive investors. This here, Sammy sponsor, obviously with the names changed to protect the innocent, but this was our client. He did a syndication for his side of the transaction through this entity, 1234 Main Street Investors. These passive investors up here are his clients. And this deal was done with a joint venture partner. Here's the joint venture, JV Equity. They had an exchange. So they brought in their money in a tick structure. You can see we owned 15% of the deal on this side, and then 85% of the deal, 85% of the equity was brought in by this joint venture partner. So this up here is just an example, and it was actually sort of the structure in our case of who owned this Deep Pockets JV entity, how that was structured. But you can see that to put this apartment deal together for Sammy's Apartment Homes, it required a tick structure here, putting together a syndication, so we had a sort of investor raise on this side. We dealt with a joint venture partner on this side. And this is, a more complicated one than is typical, but, shows you how all of these things can be put together and combined. So that's, I see we're coming back here. So that's it. That's the end. And I know we've had no questions so far, but if anybody has any final questions, we can take them now. And I've got my contact information up here on the slide. Feel free to reach out if you want to talk about questions offline. If you have a particular issue to talk about, happy to discuss.
Peter, thank you. That was some very thorough content, and it's always so important from a legal perspective to make sure that folks can get the legal structure and get the proper documents and forms ready and available to make sure that they're abiding by the SEC regulations. So if you have questions, make sure you reach out to Peter and his firm, and they can certainly help you out and address the particulars about every deal, because every deal is going to be different. That structure Peter just went through changes for every single purchase. And so, Peter, what's the one thing that a investor needs to know about getting the legal process started or underway when buying a deal? So let's say I'm an investor and I have a deal that I really like, and I'm going to submit an offer on it next week. When should I be thinking about starting my legal conversations, and what do I need to do before I submit an offer? And let's say once I have a deal under contract.
Yeah, and I think to give the official legal answer that all of clients hate to hear, it depends. But in an ideal world, you would have either your stable of investors. You'd have built them up. You would be chatting with them generally about your business, and having folks who are interested, or if it's on the joint venture side, talking to some potential partners before you find deals. Not always easy, because again, you're doing two jobs at once. You're sort of capital raising or building an investor database and finding deals. But and likewise, we always prefer that to get involved at the early stages. But a lot of investors will tie up a deal. They'll put in an offer. Hopefully they'll have some kind of contingency period, 30 days, whatever it is. And then during that time, it's a mad scramble to, do your diligence, on the property, get your financing together, find your lender. I think I have tough days sometimes, but all these sponsors who are out there running around, doing 3 different things, 5 different things, then we just come in and document it. But the sooner you can get us involved, the better, especially if you're not quite sure whether you're going to do a joint venture or a syndication, or, how you're going to put the deal together. Because once you put that deal under contract, your clock is ticking. And if you don't get the financing, the loan, et cetera, together, you may have to back out of that escrow.
Yeah, that makes a lot of sense. Well, Peter, thank you so much. Again, we are at time here. Peter, it was excellent information. I think, again, if you don't know what your SEC regulations are, you need to reach out to Peter and have a conversation. If you have a deal that you're thinking about getting under contract, make sure you have that legal plan ready to go and know exactly when to time them. So thank you so much, Peter. We are going to wrap this session, and we are going to take a break. We'll be back at 2 p.m. Eastern. We will start that session, Expert Underwriting Tactics for Multifamily Properties, with David Topin. Again, the next session that's coming up in room 3 is Expert Underwriting Tactics. So now that we heard from Peter about the legal process to get our SEC regulations in order, and which filing we need to do, and how to approach investors about purchasing shares of a private offering, we can then look at some of the underwriting tactics coming up next with David Topin on what are the deal specifics, what are the actual returns looking like, what type of conservative underwriting approach are we taking. So we'll get those tactics from David at 2 on the button, and we will come back then. For those of you who are eagerly awaiting the iPad drawing, there's a couple of ways you can enter. Register for the January 2020 summit. Go to nextmfin.com. Again, that's nextmfin.com. And you can purchase your ticket there, and you'll be entered for an iPad. You can also post a podcast review of the Multifamily Investor Nation podcast on iTunes. Take a screenshot of that review and send it to Stacy at multifamilyinvestornation.com, and that'll get you another entry into the iPad. And then the third way to get entries into the iPad drawing is by your participation. So what you're already doing right now, join 50% of the sessions, join 75%, or join 90% for different tiered entries in that iPad drawing. And so stay tuned. We will be back at 2 p.m. Eastern. We've got about 13 minutes until then, so take your break, and we will be back with expert underwriting tactics with David Topin. All right, multifamily investor nation. Let's get started. We've got our 2 o'clock session. Again, we're going to go for an hour and 15 minutes. David, if you are able to share your video, we will
Hey, Danny.
start it here. We have David Topin with us, and we're going to go through some expert underwriting tactics for multifamily properties.
Hey, Danny, can you hear me?
I can hear you, David.
Awesome. Hey, I'm going to grab my headphones real quick. I'll be right back.
All right, very good. We'll give David just a minute. He's going to get his headphones going. I'll have David give a nice introduction of himself, and then we'll go ahead and get started. While we're waiting for David, for those of you interested in the January 2020 summit, go to nextmfin.com. You can get your ticket. I think we've got the low price of $97. It will not be any lower than today's price. So buy your ticket today and lock in that lowest price that's available. That'll also get you an entry into the iPad drawing as well. David, good afternoon, sir. How are you today?
I am doing phenomenal. Hope you guys are all doing great as well.
Excellent. Well, David, give us a little bit of background about yourself personally, professionally, and then I'm excited. We're going to get into the underwriting tactics that you have.
Dude, I'm excited too. Thank you guys for having me on here. Hopefully you guys all get a lot of good value. It looks like we've got about 30 participants watching. So a little bit of my background. I probably look very young. It's because I am. I started when I was, 19, turning 20. I was in college. I bought my first multifamily deal. I had no money. I raised from investors. So I've pretty much only syndicated since I've gotten into this. And I bought a 12-unit building. Shortly after that, I bought another 12-unit. And before I graduated college, I had acquired about 120 apartment units. And then I went on, graduated. I self-managed those properties. I actually lived on site of my biggest one. It was 100 units. And I moved in there so that I could work closely with my on-site manager and maintenance person. And I didn't know how to manage very well, and I wanted to learn the management business. So what I did was I moved on site, really learned the management side. I think my specialty is the numbers and underwriting. That's kind of how I got started. Was I had a little bit of an accounting and finance background, did a little investment banking internships, and I got really good with the numbers. And I built this model, which I'm going to show you guys and kind of walk you through how I run the numbers. But I guess long story short, I proceeded to go on after that, and I've bought a little over 520 apartments now. I'm doing a 50-unit ground-up development in Austin. I moved from Michigan to Austin a couple months ago to keep my business growing here. And we're rocking and rolling, looking to buy another 500 units this year, 1,000 units this year, and keep growing.
David, I love it. Well, it's just an amazing story. I think, one thing that the summit attendees should take away is that you saw a deficiency in your ability to manage, and so you just moved on site. Pretty simple. Put yourself right in there with the residents, with the property manager, with the on-site team, figure out what it is that they do on a regular basis, which I'm sure led you to have some very key findings for items that you analyze your underwriting with. So not only from an income perspective of how do we calculate rent premiums for our 1 or 2 or 3, whatever bedroom units that we have, but how do we manage our expenses? And really that oversight of expense, I think, is so crucial to underwrite. Totally. And, there's some very distinct differences between, I'll say, smaller apartments, less than 50 units, compared to larger communities, more than 50 units. And so I'm excited. I think, we've got a very good group of attendees here who are just as excited and ready to really learn some of these underwriting tactics. And I think if you could please, David, just talk through the spreadsheet when you go through it as if you're
sure.
Explain it to an elementary school student. Take anything that from Excel tricks with you. please leave those aside. And so that way everyone can have an equal opportunity to learn, what you're doing in that spreadsheet or what that cell is calculating when you get to it. And I always think, if I could explain this to my 7-year-old niece, which I understand, that's what we're looking for here. So I'm going to shut myself off. I'll mute myself so you don't hear me anymore.
No worries.
We're gonna hand it over to you. The stage is yours. We've got another 75 minutes or so. We'll go until 3:15 Eastern, and so the stage is yours. Get us your underwriting tactics. Walk us through your sheet. If there's questions that pop up, there's the Q&A box. Do you have access to that? Perfect. You've got the chat box, and are you able to share your screen?
Yes, I will be sharing my screen for sure. And I'm going to walk you guys kind of through everything on that. And you can feel free to chime in if there's something that maybe I didn't explain well, or you think you want me to dive deeper in because you think it's a good point. Please feel free to jump in. I've done a lot of these webinars on underwriting, exactly what I'm going to show you guys. I've done a lot in my Facebook group. So I keep it super casual. I really don't have anything specific planned out. I just want to walk through what the model's all about, why it's important to have a good model, and hopefully you guys will be able to grasp it. You can, jump in at any time and ask a question. Like I said, I'm gonna keep it very casual, and feel free to stop me at any point. There's no such thing as a dumb question. Not everyone is good at with numbers and underwriting, and so I think